This is online lecture 8, where we finish up talking about evidence and the Fourth Amendment, and we discuss self-incrimination and the Fifth Amendment. So, to review the Fourth Amendment briefly, what we are talking about is the right to be free from unreasonable searches and seizures. We just left off with a discussion of the exceptions to the search and seizure rule and the development of the exclusionary rule to exclude evidence that is discovered in violation of these regulations. So, the exclusionary rule, as I mentioned last time, developed mostly federally until the Mapp versus Ohio case in 1961 made it applicable to the states. But in the time since 1961, we have seen a significant reduction in the willingness of the Supreme Court to apply the exclusionary rule, especially in recent years. And this becomes important for understanding where the law is today. So in 1984, we have a warrant that, for all intents and purposes, is invalid. But the police don't know it at the time. They believe the warrant is valid. There's a question as to whether that's true or not. And that's why the dissenters are quick to point out that maybe we shouldn't abandon the exclusionary rule. However, assume the warrant is invalid. And the question is whether the exclusionary rule should be invoked to bar the use of evidence obtained using a warrant that is believed to be valid but later found out to be invalid. And the court says that here there is no need to use the exclusionary rule. And their reasoning is this. If police believe that they are doing the right thing and they are following the right steps according to procedure, then the use of the exclusionary rule serves no deterring purpose. So it's not necessarily a given that the exclusionary rule applies. We tend to think of it that way, that it's fruit of the poisonous tree and therefore is not admissible, but that's not the case. In Hudson versus Michigan, we are talking about a technical violation of the Fourth Amendment protections, and that is the knock and wait rule. The knock and wait rule, when you have a warrant, developed in order to protect the safety of both the occupants of the dwelling and the police as well. Essentially, you know if someone's standing behind the door, and people behind the door know the police are about to enter. When the knock and wait rule is not properly observed, like it was here, so the police violated the knock and wait rule, should the evidence obtained from that search with a valid warrant be excluded based on the failure to wait after knocking? And the court said no. There's no use for the exclusionary rule here because there's no protected interest in prohibiting the government from seeing the evidence that is described in the warrant in the first place. This is a valid warrant, validly obtained, with appropriate documentation and backup, and therefore the warrant is not invalid insofar as it should exclude the evidence from the case. Finally, in Herring versus U.S., now, this case should give you more pause maybe than the previous two. Herring is a convicted felon who was out of prison and whose truck was impounded at the local sheriff's station. He went to pick up some items from his truck, and while he was there, the sheriff asked the secretary to run his name through the database to see if there were any valid warrants in neighboring counties. They found one. They called that county to see if it was a valid warrant, but before Herring left, they weren't able to verify that it was still valid. So the sheriff, wanting to stop Herring and essentially singling him out, very much because he was easy to single out. He was someone who was apparently on meth and was a convicted felon, stopped Herring, arrested him based on the warrant that they found in the system, did a search, found meth and a pistol, and the pistol he was not allowed to have as a convicted felon. And it turns out later that that warrant was invalid. They finally got a return call from that county, and it turns out no valid warrant. So can the meth and the pistol be used against him in court? This would be the kind of thing you would expect to be inadmissible. But the court says the evidence is admissible. And this is where you get people arguing about the exclusionary rule. It isn't so much the knock and wait case, although there are reasons why that's an important case too. But the majority opinion here says that the exclusionary rule is not an individual right, and it only applies where you could deter officers from doing the wrong thing in the future. In other words, if you can't deter bad behavior, then you don't exclude the evidence. But the dissent has two problems with that, and I think a lot of people have two problems with that. One is that excluding the evidence was never meant to be just a deterrent, but also to kind of bolster the Fourth Amendment right. The Fourth Amendment right doesn't mean anything if they can still use the evidence. But second, really this incentivizes police officers to not look any further into warrants that they believe might be expired. Arrest warrants, that is. So let's say you just look in the computer, you see an arrest warrant, you're not sure about it. This would actually incentivize you to not look it up because you know that the evidence is not going to be excluded under these circumstances. So it really depends on where you come down on this type of issue, on how you feel about law enforcement's use of warrants. This situation is probably not typical, but it certainly isn't out of the complete realm of ordinary. So now that we've talked about Fourth Amendment rights, we do need to talk about the Fifth Amendment right. In particular, the Fifth Amendment right against self-incrimination. We don't deal a ton about double jeopardy in this case, and due process is kind of a lengthy set of rights that incorporates some of what we've already talked about, Fourth Amendment, Fifth Amendment, Sixth Amendment, and so on. But the Fifth Amendment right, you'll see it's that second highlighted section there that says, nor shall be compelled in any criminal case to be a witness against himself. This is a pretty uniquely American right. Many countries don't observe this right or this privilege, and so interpreting it is something uniquely American. The first question you have to ask is, what is an interrogation? In the Escobedo case, 1964, we have a man who was a Mexican immigrant, could not really read or write that well, was arrested for the murder of his brother-in-law, asked to see his attorney. His attorney was actually in the other room and asked to see him, and they were both denied their requests. And then the police proceeded to interrogate Escobedo for 14 and a half hours without counsel. And at which point, about 14 and a half hours in, he made some incriminating statements. Now, we have learned in recent times, especially with some higher profile cases, that incriminating statements can be made under duress even when there's no incriminating circumstances surrounding them. So that aside, the question for us is whether the refusal by the police to honor his request violated his Sixth Amendment right to an attorney. And you may be thinking, why are we even talking about the Sixth Amendment? I thought we were talking about the Fifth. And you're correct. However, the reason why we're talking about this case here is because we have to determine what is an interrogation. When do these rights begin and end? And so the court found that the statements were inadmissible, in part because he didn't have an attorney, but in part because of this privilege against self-incrimination. And they said, you know, every person is entitled to an attorney, but the question is, what is an interrogation? And the answer is where the investigation is no longer a general inquiry into an unsolved crime, but focuses on a particular suspect. The suspect is in custody, and the police carry out a series of interrogations that leads to incriminating statements. And, like here, the suspect has requested and been denied an opportunity to consult with an attorney and not been warned of his right to remain silent. His statements cannot be used against him at trial. Now, that was a pretty lengthy set of circumstances. So you can see how this case, you know, only helps a certain portion of the population. You have to have a singled out suspect. You have to have a request and denial to consult with an attorney, failure to warn about constitutional right to remain silent, custodial interrogations, and so on and so forth. This is not every case. 14 and a half hours of interrogation is not every case. That's where we get the Miranda case. Miranda was a 23-year-old indigent, uneducated truck driver who was accused of kidnapping and raping a woman. The police arrested him 10 days later, took him to the station, and interrogated him. After 2 hours of questioning, he confessed. Your book goes in to tell you about what happens to Miranda after the fact. There is not a lot of debate that Miranda was not the best guy. There is enough, I think, in the history to suggest that he probably suffered from mental illness as well. Be that as it may, after 2 hours of questioning, when he confessed, can those statements be used against him in court? And the court said no. The prosecution cannot use statements, either exculpatory, meaning they help him, or incriminating, that stem from a custodial interrogation of a defendant, unless it demonstrates that procedural safeguards were used. What procedural safeguards? Well, prior to questioning, the person may be warned, and this language comes directly from the case, mind you, that he has the right to remain silent, that any statement he does make may be used as evidence against him, and that he has the right to the presence of an attorney, whether retained or appointed. He is also to be told that he may waive these rights, and he can only waive these rights legally if that waiver is made knowingly, voluntarily, and intelligently. All three of those things. If he asks to speak to an attorney prior to speaking to the police, there can be no questioning until he has spoken with his attorney. So this case, it's infamous or famous, depending on how you want to go about it, for a very specific reason, and that's the court outlined the language you hear on all of these procedural cop shows, which is you have the right to remain silent. Anything you do or say may be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one can be appointed for you. That language, I've never been through police training, but I know from watching Law and Order, and I'm sure you do too. And it comes directly from the case. Because that is the language that people need to hear to be on notice of what their rights are. And so the Fifth Amendment privilege against self-incrimination isn't just in a court setting, which is what the government of Arizona was trying to argue. It's not merely when you're put on the witness stand, or that you can refuse to be put on the witness stand, but instead has very much to do with any time you are detained by the police in a situation where your freedom is curtailed. So we next have to stop and think about interrogation techniques. The timing, phrasing, and staging of the circumstances around the Fifth Amendment guarantee and the delivery of the Miranda rights very much impacts how the Miranda rights are perceived. So Missouri versus Siebert, 2004 case. Siebert, again, not a good individual. By the way, the one thing I forgot to mention, which is in your book, is that Miranda was later arrested on another crime, served time in jail for that, and then was killed in a bar fight in 1976. So he did not live a long life after that case. Missouri versus Siebert. Siebert, again, arguably not a great person. Probably not even arguably. So Siebert had a son with cerebral palsy who died in the home. And I guess there were enough sores on the child's body that she knew she was going to be charged with neglect when the authorities came. And so in an attempt to destroy the evidence of this, she concocted a plan with her two sons and their two friends that they would light the house on fire and burn it down and claim that her son died in the fire. In doing this, not only did they leave his body in there, but they thought that's not enough. They're going to suspect something. We have to do something more. And so they also left in the home a mentally disabled person who had stayed with the family before. And he did die in the fire. So what also happened in the fire is one of her sons was burned badly enough that he was in the hospital. And so while at the hospital, she's approached by the police. The police asked to speak with her and say, we need to take you back to the station to speak with you about this. She goes back with them. The officer that she was with was told by his superiors not to give her Miranda warnings at first. So they get her to the police station, get her talking. She makes some statements that could be incriminating. And then they take a break for cigarettes and coffee. They come back, turn the tape on, give her Miranda rights, and then say, now what you were saying before, can you repeat what you said about X? Can you repeat what you said about Y? And she repeats the incriminating statements she made prior to the Miranda warnings being given. The question is whether this interrogation technique passes the Fifth Amendment test. Because technically, they're not using the statements from before the Miranda warnings, they're only using the ones after. But are the Miranda warnings effective in this case, where she's already been talking to police for at least 40 minutes? And they find that her rights were violated. The statements cannot be used. And they say that when Miranda warnings are inserted in the midst of a coordinated effort to interrogate someone, they're likely to mislead and make people think that they were there all along and that they don't have a right to stop talking. Part of the Fifth Amendment privilege against self-incrimination is knowing when you have the right to be quiet and that it's a continuous right. And if you are giving mixed messages as to whether someone has that right or not, that can be seen as violating their Fifth Amendment rights. So here, the statements that Siebert had made could not be used against her. Which, again, kind of like some of the other cases we've seen, doesn't make you want to really side with this woman knowing what she had done. But when you're talking about protecting a fundamental civil liberty, it does make you want to uphold that. So, tough case, tough facts, but the police need to be clear on these laws. So the questions to ask in these situations, if you're looking at a set of facts, the questions you should be asking are listed here. In the Fourth Amendment situation, first, is there a warrant? Is it valid? You need oath or affirmation, sufficient probable cause, and a neutral magistrate. If you don't have that, if there's no warrant or it's invalid, is it a search and seizure? If it is a search and seizure, is it done without a warrant? Does it fall within one of the exceptions to the rule? And then finally, if there's a violation, no exception, no warrant, etc., should the evidence be excluded under the exclusionary rule? That's a separate question from the Fourth Amendment right being violated. On the Fifth Amendment side, is the person in custody of the police? If they are, you have to Mirandize them. If there were Miranda warnings, were they properly given, and were they given before statements that were made? In the case of the Fifth Amendment, unlike the Fourth Amendment, at least in modern interpretations, if the statements are made and there are no Miranda warnings given, or improper Miranda warnings, the statements cannot be used. There's no corollary to the exclusionary rule under the Fifth Amendment. The statements just cannot be used. So that is something that, is obviously always up for development, but at least at this point is not a separate question you need to ask. So I will leave it there, and we will talk in class further and develop this through our case exercise.